Are you representing the McCloskeys anymore, and if not, why not?
All right, so I am no longer counsel of record for Mr. and Mrs. McCloskey with the I beg your pardon, with the Circuit Attorney's Office. Any criminal defense work is going to be handled by Joel Schwartz. My ability to move forward on behalf of the McCloskeys is compromised by my potential role as a witness in this case.
Why? Why are you witnessing the case now?
Because I have possession of and will be part of the transfer of possession of this weapon to law enforcement.
How did you come into possession of the weapon?
As attorney for the McCloskeys, it was my duty and my obligation to make sure that evidence was preserved to maintain the integrity of the defense of Mr. and or Mrs. McCloskey in the event, in what I believe to be the highly unlikely event of any charges being brought.
How do you have possession of the handgun and not the rifle?
The rifle is not one that I was concerned about because the rifle was A, not flourished, B, it was not held in a fashion inconsistent with what Mr. McCloskey lawfully could have done in the produce department at any Schnucks. This gun, which was not operable and was being handled by Mrs. McCloskey, was clearly being handled in a fashion inconsistent with anyone with any sort of gun or weapon training. So the importance of having the integrity of the inoperable nature of this weapon was important, given the elements of any potential crimes which may, in your wildest imagination, arise out of the fact situation which occurred June 28 in the front yard of and on the private property of the McCloskeys in Portland Place.
Has it always been inoperable? When did it become inoperable?
So this was used as an exhibit in litigation that, not just one piece of litigation, but multiple pieces of litigation that have been used in court over the years, many years, I don't know the exact number of years, but the inoperable nature of this weapon preceded December 23, 20, or December 20, I'm sorry. The inoperable nature of this weapon preceded significantly June 28, 2020. The date this weapon was in the hands of Mrs. McCloskey.
Was she aware that it was inoperable?
Yes, she was. Yes,
So
she
it
was.
More of a
She had no training at all.
when she was standing on the yard with the gun.
Well, yeah, it's the intimidation factor that you utilize within the context of any self-defense, yes.
Describe how was it rendered inoperable? I mean, could you still load it and fire it at some point?
Is it what?
How is it inoperable?
Well, first of all, the manufacturer of the gun has been sued multiple times because of a defective design which renders it operating even when you don't want it to operate, meaning it discharges when it shouldn't discharge. So this gun was rendered inoperable, and I'm not a firearms expert, but I do know that steps were taken which required the dismantling of the gun and the reassemblage of it in a fashion that would render it safe and acceptable for utilization as an exhibit in state and federal court.
Did Mrs. McCloskey have any gun training? Obviously, the way she was holding it, pointing it, did she not understand not to point a gun?
First of all, Mrs. McCloskey was absolutely, she was not in a state of mind to worry about whether or not she had training or not training. She was angst-ridden beyond description. Clearly, looking at the images of Mrs. McCloskey waving the gun that can be depicted, you can't, I've joked about it, and I'm being very respectful when I say, it wouldn't have surprised me if she used the gun to clean out excess earwax. This is not, her handling of this gun was clear indication that this was not something that she had planned, nor was it something that she was skilled at or well versed at. As to whether she had training, my guess with 99% certainty is absolutely not.
So you said that McCloskeys kept the assault rifle because it was not likely to be contentious because Mr. McCloskey handled it in a way that's consistent with training and there wasn't a threat to the public. Is that correct?
Mr. McCloskey, I didn't say that. I said Mr. McCloskey, and I didn't finish my thoughts, but I appreciate your question. Mr. McCloskey handled that weapon, such as to not have his finger on the trigger, such as to not have the safety released, and the gun was not flourished in a fashion that was anywhere near akin to that which was exhibited with a weapon that wasn't operable.
Was the rifle seized in the search warrant yesterday?
I beg your
Was
pardon?
the rifle seized during the search warrant execution yesterday?
My understanding is it was. It was just turned over. There's no search required. Here you go. The McCloskeys are both attorneys, are both members of the bar. They're completely cooperative with law enforcement. There was no tension. The police were very respectful. They were apologetic for having to bother them, and it was perfectly respectful, mutually respectful interaction.
But he did hold the weapon in such a way that he had it pointed at his wife at various times on June 23rd. That's not consistent with proper weapons training, is it?
So I'm not, as I've made clear, I'm not a weapons expert. I can tell you, in looking at the one-dimensional videos that do appear on social media, you can't really tell what is being pointed where and whether, because the images are going toward the McCloskeys, you can't tell whether those weapons are really pointing at anybody.
Okay.
But that's a good question, and hopefully when more video becomes available, and I'm quite certain it will be, we'll all be able to get something that trends more closely to a three-dimensional view of what happened and what the McCloskeys were addressing, and I think it'll obviate a lot of the optic repulsion which may have been associated with the first images that were released of the McCloskeys.
Should there be charges here, is it legally relevant in your mind whether or not the gun was operable?
In my opinion, it's only legally relevant to the extent that some charges, one charge in particular, unlawful use of a weapon, requires a weapon that is readily capable of grave bodily harm. And if you have a weapon that's not dischargeable, obviously that element of that particular charge could not be met.
What if somebody were to have pointed a gun back at her, though, and fired it in fear for their own life, and it was an inoperable gun? I mean, did she think about that at all?
Well, you know, I can't tell you what anybody was thinking during a period of complete abject fear. I can tell you that if you are a lawful trespasser and you are on someone else's property, in this case the McCloskeys' property, and you point a gun at the McCloskeys, in their home, on their property, my suggestion to you is that's the very reason why the McCloskeys and their actions on the 28th of June occurred.
Someone pointed a weapon at them?
No, I'm suggesting to you that the fear and the apprehension was caused by the display of weapons, by the display of rounds of ammunition, the statements, the overall combination of actions of individuals that were in that group of people. And I'm being very sensitive about and not attributing those people to anything associated with BLM.
Looking back on it now, do you have any second thoughts or regrets about going on national television? Do you think they have become, in part because of your actions, a bigger national story?
Well, I think, as I said on CNN the first night and on Fox News with Tucker Carlson, this nation needs to have not one, but two discussions. One discussion has to do with the noble message of Black Lives Matter. The other has to do with the concurrent discussion that's necessary about the need to not shroud or otherwise encumber or render compromise that noble message by virtue of actions of individuals who really don't have that noble message in place. Detective?
We're coming here now.
Oh, okay, very good.